Hello everybody, welcome to my channel. Today we're going to see about memorandum and articles of association, the primary company documents that is necessary for incorporation. And in this chapter, we're going to see what they'll ask in a law officer examination from this particular chapter. So we learn about the memorandum, that is MOA, that is the company's document for the outside world, and doctrine of ultra vires, the articles AOA, that is the internal working document for the companies, and how the MOA and AOA can be altered, and the two key doctrines, that is constructive notice and indoor management. So the memorandum of association is the company's charter. It is similar to what is like India's constitution. So this is the grand norm under which the company operates. So the memorandum has 6 important clauses, that is the name clause, liability clause, register office clause, capital clause, object clause, and subscription clause. So I did not go and explain in detail in all this. The description is very clear. If it's a name clause, it describes the company's name, that if it is a limited or private limited company, and register office clause, liability clause, and all those things. So the name says it all, so there's no need to further explaining these things. Now this is a very important key doctrine, that is doctrine of ultra vires, which means a company cannot do anything against its object clause. So during incorporation in the memorandum of association, the company has to put out its object, and if it performs anything outside the objects, no matter what, even if it is ratified by the board or the shareholders, the company's actions would be considered ultra vires. So this is a very important ultra vires document, which in simple is the company will have an object clause in the memorandum of association, and if the company does anything that is beyond the objective, then it would be deemed as ultra vires and it will be deemed void. Next, we are going to talk about the articles and the acts supremacy. That we all know, the Companies Act is the overarching legislative framework under which the company's law operates. So when you have MOA and articles of association, they would have their own clauses. And what happens if there is a clash between articles of association and the act? So if there is the articles of association and if there is a clash between the Companies Act, remember the act will always prevail. So the articles of association, though it is an internal rule book, whenever there is a clash between the articles of association and the act, that is the Companies Act, then the act will always prevail. It may also contain an enrichment provisions, that is there are particular clauses which would require a stricter conditions to alter. And of course, we all know the articles of association and memorandum of association can be altered by the special resolution, that is 75% of voting by the shareholders. Now, alteration of MOA and AOA, like I said, by a special resolution, it requires special resolution. Special resolution is nothing but 75% of the votes. So both the memorandum and the articles of association need special resolution. There are certain changes which would require the stricter conditions, especially the central government approval, like the name change or shifting of the register office to another state. So these are very important things. This is something an MCQ can ask, how an articles of association MOA can be altered. So it's by the special resolution, and it is done through the voting of the shareholders. There is 75% above, and if there is a requirement to change the name of the objects or something like that, then or to shifting of register office, then the central government's permission would be required. And it is very important to note that such alterations should not violate the fundamental principles in Companies Act. With this, we would conclude this short topic on Memorandum of Association and Articles of Association and the doctrine of indoor management. And yeah, I have to still explain you two important doctrines: the doctrine of constructive notice and the doctrine of indoor management. So before I talk about this doctrine, the doctrine of constructive notice means a person should ought to know what is obvious. Like I say, if the articles of association and memorandum of association, which is a public document, the company would expect that the person who is dealing with the particular company would have read it. Now, this is called the doctrine of constructive notice. Even though the company does not bring a specific or draw the attention to the specific articles to the external party, the court expects the external party to read what is available in public. So tomorrow, somebody who is dealing with the company cannot say that we have not read it. So if there is anything that is in the articles of association or in the memorandum of association, so whether you read it or not, by the doctrine of constructive notice, the courts will assume that you had knowledge of it. So this is a company protective clause. The companies, this clause which protects company, and the outsiders are deemed to read the contents of the articles of association and the memorandum of association. Now, doctrine of indoor management is something that is antithesis to constructive notice, which is kind of protective to the third parties who are dealing with the company. So this came up in the famous Royal British Bank versus Turquand, where an outsider dealing with the company would think that the company's internal policies or the company's measures under articles of association are followed in letter and spirit. Say, for instance, for a specific transaction, the articles of association requires certain voting percentage or certain process through which a board or the shareholders has to approve. The third parties would assume that such internal approvals are taken. Tomorrow, the company cannot say that, let's say, an authorized representative from the company signs, and the company's board cannot claim that we did not authorize him. We did not acknowledge the particular transaction. This cannot happen because the third parties, by virtue of the doctrine of indoor management, can assume that all internal regulatory process have been followed in letter and spirit. So these are the most important doctrines that you must remember. Now, we have talked about the doctrine of indoor management, that is Royal British Bank versus Turquand, and then the doctrine of constructive notice. And another doctrine that we have talked is the doctrine of ultra vires. The key case law being Ashbury Railway Carriage versus Riche. So these are the important cases, that is Ashbury Railway Carriage or Royal British Bank and Salomon and Salomon. These are completely important case laws that you have to remember. So today in this lecture, we saw three important doctrines, that is doctrine of ultra vires, that is a company should not do anything about beyond its object clause. Then doctrine of constructive notice, that is that anybody dealing with the company can assume that they have read their memorandum and articles of association, which are public documents. And then doctrine of indoor management, where the third party can actually assume that the company's internal procedural mechanisms are followed in letter and spirit. So with this, we conclude today's topic, and we have seen what is memorandum of association, what is the clauses, that is name, object, liability, subscription clauses, what are the ultra vires, what is doctrine of ultra vires, the key case law being Ashbury Railway, and articles of association, how they can be changed and how they can be overrun. What if there's a clash between the Companies Act and the articles? The Companies Act will always prevail, and alteration of MOA and AOA can be done by the special resolution. Then we have seen the most important doctrines, that is the doctrine of constructive notice, which protects the company from any stand that is taken by the third parties, and the doctrine of indoor management, which is a counterintuitive doctrine to constructive. Notice that it protects the third parties from any adverse claims by the company's board later. So the rules that outsiders may assume a company's internal procedure were followed is the doctrine of indoor management from the Turquand case law, or it's called the Turquand rule. So this is one question that you can test yourself. So with this, I have concluded this topic. So if you have any doubt, do type in the comment section or ask me. I would clarify it. So the next lectures would be the prospectus and allotment of securities. With this, I conclude today's topic. All the best for your examination.